The Supreme Court's decision on California's Prop 8 has made, by default, same-sex marriage legal again in California. But the reason behind the ruling could undermine voter-approved initiatives in our state and 26 others. Here with more on what's at stake are political science professor Thad Kauser and San Diego attorney Dan Eaton. Welcome back.
Thank you very much.
Dan, the justices decided that Prop 8 backers had no legal standing. What is this criteria for legal standing?
What Chief Justice Roberts in the majority opinion was saying was, look, to be able to appeal the court's ruling that struck down Proposition 8, you had to have suffered concrete and particularized injury under the U.S. Constitution, which allows you to go forward in federal court and federal appeals. And what Chief Justice Roberts pointed out was the district court order didn't order the proponents of Proposition 8 to do anything. It was directed at state officials and said you can't enforce Proposition 8, and to county officials and said go forward with the licenses.
So when it comes with a concrete injury, perhaps people wanting to get married could argue that they are suffering injury because they're not allowed to, but the backers of Prop 8, they weren't suffering any injury.
Had the same-sex couples who sought to be married lost Proposition 8, they would have had standing to appeal, of course, because they would have been deprived of their right to marry.
Thad, how could the issue of the standing impact our initiative process here in California?
Well, I think regardless of how you feel about the policy implications of this decision, allowing same-sex marriage in California, you can't argue that it's created great collateral damage for direct democracy, because what it means is that initiatives passed by the people, if the governor and attorney general and state leaders decline to defend them in court, and they are challenged so often, it means they don't get their day in court, and they could go by the wayside, not because they've lost in court, because they've never had that fight.
Four justices agreed with that, the initiative process and their dissent. Justice Anthony Kennedy said the court's majority failed to grasp or accept basic premise of the initiative process. He explained the essence of democracy is that the right to make a law rests in the people and flows to the government, not the other way around. Dan, what is he saying with this? Is it what that is saying?
Of course, yes. And what Justice Kennedy, of course, is a Californian. And what the basic issue is this. An initiative is a power given to the people to curb public officials. Well, what this ruling means is that those same public officials that the initiative process is designed to curb can de facto veto an initiative popularly passed by declining to defend it, at least for the purposes of a challenge brought in federal court.
Well, and in fact, Governor Brown, when he was Attorney General, did not defend it, saying that he thought that this was unconstitutional. Is there a valid legal argument for elected officials not defending what is, in this case, an initiative, but state law?
There is a strong argument, actually, Peggy, that they have a fiduciary obligation to defend the laws that are popularly passed, but that argument ultimately was not successful, and so here we are.
But Thad, this isn't the first time this has happened by far. Give us a little history of initiatives in California and what passes and what goes to court and what doesn't.
Well, California, since 1965, 69% of the initiatives passed by voters in California have been challenged in the court, and a third of the initiatives passed by voters have been actually thrown out by the court. So this happens all the time. We've seen it with Proposition 187, the ban on public services for illegal immigrants, thrown out. Prop 22, the statutory ban on gay marriage, was thrown out a few years ago. And initiatives that people on the left have like a campaign finance reform initiative, thrown out by the courts. This happens all the time.
Is it, Dan, is that a good thing? I mean, is it a good thing that these go to court, or is that really like our initiative process isn't so great if we're constantly having to go back to court to settle it?
Well, let's be clear. Courts throw out things that are passed by legislatures, and legislators vow to uphold the Constitution as well. That's what courts are for, and they ultimately have the last word.
Okay. And Thad, what do you think is going to happen next?
Well, I think we may see some calls to actually change California's Constitution to explicitly grant a right to the proponents of initiatives to defend what they say in court. And I think if that was put before voters, probably would be pretty popular.
And Dan, do you think anything is going to move forward on this?
Well, I don't know if it'll ultimately pass, but it's not clear even if it were to pass, it would pass muster in federal court, which is a critical issue for purposes of the Constitution.
All righty. Attorney Dan Eaton and political science professor Thad Kauser, thanks so much for this update.
Sure. Thank you, Peggy.